following program on Ada Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we discuss the legislature surrounding cooperative laws in Sri Lanka. How does the legal framework aid the development of cooperative enterprises? And what do these laws mean for Sri Lanka's future? A very good evening and thank you for joining us on yet another episode of Law, Land and Liberty, where we bring to you key legal concepts and break it down for the layman. Tonight's topic is on cooperative law. Now, I'm sure we've all heard of co-op banks and co-op integrations and of course co-op institutions, but what exactly does co-op mean, and especially in a legal context, how exactly is cooperative law even instilled? Well, to speak about this topic, we have someone that's not a new face on the program, and that is Attorney at Law Krisantha Nissanka. So thank you very much for taking the time to speak to us today on this very important and very timely topic, as well as we will understand in the coming few segments of this program. A small introduction on Attorney at Law Krisantha Nissanka. He is specifically the convener for Lawyers for Buddhist Rights as well. As you may have remembered from one of our previous programs, safe to say we're in good hands when it comes to this specific topic and also what it entails in the current context. Well, before we get into the topic, here is a breakdown of how exactly we're going to approach cooperative law. First off, we'll be talking about the fundamentals of co-op law. What exactly is co-op law? Next, we'll be going into the global context as we see current developments that are relevant to co-op law and how it's changing the legal field. And finally, we'll be talking about the evolution of co-op law in Sri Lanka and across the world.
Hi, my name is Sahan Virakodi and I'm a marketing management graduate. My question is on the fundamentals of corporate law. What is the historical significance of these laws and what is its current standing?
All right, well, without any further ado, let's get right into this very packed discussion. So thank you once again for taking the time. It's a very complicated topic and it's been part of our history for a long time. We're one of the countries with cooperative law actually in its legal framework. So before we get into any of the specifics and the current issues that cooperative law is actually facing, could you please explain to us a little bit about the basics, the fundamentals of cooperative law? Where's the legislature and how is it actually being carried forward in the current context?
The term cooperative, right, differs from cooperation. So cooperative law is the word itself was introduced to us, the English term was introduced to us, say around 100 years back, a little more than 100 years, 1911 like. So that is the first time we came to know the word cooperative law. But historically, the people of this country knew what cooperative was, but this particular word cooperative came into being 100 years back, and the particular term cooperative was used in an English context. That is, for the Westerners, cooperative was I should call it a new concept, because they knew little of cooperative. Right? For them, the revolution on cooperative began in 1840 with the Rochdale trade union, because they used this particular term to overcome their economic difficulties, emancipation of economic difficulties, and they made a particular movement towards that end, and that particular word came into momentum because the English law understood it in that context. And then going along with that, this particular law was introduced to India during that period. Now for us, cooperative, the average man's knowledge on cooperative was based on the cooperative societies. Cooperative is one thing, cooperative society law is another thing. So this cooperative societies began functioning during the war time, because it was very difficult for the the British government found it very difficult to distribute basics among the people at that time. All the army and police officers were engaged in war issues, and they wanted more people to distribute things among the people, basic needs, the food and the rest. So it became very important during that period. And then in 1972, a paradigm shift took place. I mean, that was the newly appointed revolutionary government, I should call you, because we became independent from the British rule, and a law was enacted through the Jatika Rajya Sabha. At that time, it was not called Parliament. After the 1972 Constitution, the Jatika Rajya Sabha, National State Council, introduced this particular act. It's called Samupakara Samiti Ajna Niti Panatha. That is Cooperative Societies Act. And that was the time which the people enacted this particular law, because the term cooperative differed from the Samupakara concept. Samupakara is the Sinhala term. It was the people who enacted this law actually. It was their suggestion. And the meaning given to the cooperative was differentiated from the original cooperative concept. Subsequently, in 1972, as I said, the new act was passed. That was number 5 of 1972. And from then onwards, there were 2 or 3 amendments thereafter. And now the government has decided to amend the act once again. And that has become an issue. And that is why I am here to discuss that matter, because the Parliament has decided to revise the policy of the Cooperative Act, and at the same time, because the activation of the 13th Amendment, the cooperative which was stationed, the linear department which was stationed in the city, is been taken to suburbs, that is to the provinces, and they have started working on that issue, and they are decentralizing the cooperative department, which I believe is against cooperative principles, because the purpose of having a cooperative movement or a cooperative society is not to tear apart the cooperative, but to put all people together. The strength of the cooperative is to have one singular cooperative movement or a law, whereas now the main argument against the existing cooperative is that they are not profit making. That is the main issue. So now, as the country is in a dire state, how can the government decentralize and have the same officers throughout the country? They failed with the major project, that is centralized linear cooperative department, and now they are going to dilute it and have 9 instead of 1. So when they have failed in the original thing, how, I don't know how they are going to succeed with 9 organizations. And more than that, that dividing the cooperative into several cooperative associations, several laws, giving the provincial councils to decide upon the cooperative from their own perspective, is against the cooperative principle. That is, I would like to take this up by defining the corporate law principles. What do you mean by cooperative? Cooperative, as I said earlier, the English concept was a very recent development, whereas our cooperative principle is not the same as the English cooperative principle. Why do I say this? Because the English cooperative system is a novel one. Their experience is less than ours. We, the people of this country, have practiced the cooperative from a different, the word cooperative is not the appropriate word. Samupakara is not the cooperative. We have been helping each other throughout history. Now take for instance the agricultural cooperative system we had was called Attama. Now I saw this particular word in the cooperative, National Cooperative Council papers. I saw this particular word. I'm happy that they have at least identified that particular thing, because the cooperative identity is the most important thing. So Attama, that is, it's not a profit making process. It is sharing. The basis is sharing labor, because a particular man, if one is not in a position to look after his, do the aswadhavization in his own land, what he does is, he calls the other villagers to come and help him. And he will do the same with the other members of the village. And by doing so, he will emancipate his difficulties of having a lot of money to do his own field, that is his paddy field. So this concept was there, but unfortunately our authorities have not identified these important principles as a guideline to interpret the cooperative movement. So my position is that cooperative, the English term, is different from the samupakara content. The word samupakara has so much to do with Buddha Sasana. That is samma upakara. Because in Buddhism, it's been described as samma is the correct way of doing things, and upakara is defined in the Sigalovada Sutra. And this particular term is very well known to the people. It's the throughout many programs I have stated this fact, that the law is created by the people of this country. Even the court should consider the intention of the people who created this law. Earlier, before 1972, it was the Western, English government, and through their parliament system, they decided what the law should be. So in their country, they try to find out the intention of the parliament, whereas in our constitution, the present constitution, it is more than the intention of the parliament, it is the intention of the people. So when a particular word is being used, I think we should consider the language of the people and the language, the word given in that particular language to a law. Right? The word is samupakara. So samupakara is, in the proper sense, it's not a profit making thing. It is to help each other.
Exactly, and I think that is the contentious point right now with
Yes.
the dire economic strictures that we are in, and also considering the global context as well. We have a lot more to dive into that specific segment, but before we do, unfortunately time has come against us in this segment. Let's take a very short commercial break. You're watching Law, Land and Liberty. We'll be right back.
My name is Jason and I'm a business student. My question is on the future of copper. How will the current proposed changes relate to the evolution of the law in Sri Lanka?
Welcome back to Law, Land and Liberty. We are in discussion with Attorney at Law Krisantha Nissanka. We're talking about cooperative law. So we just left off on what I believe is a good introduction, a solid foundation for us to understand the rest of this issue at hand. It's a very timely topic. It's unfolding in real time as we speak. And if we do not really acknowledge and pay attention to this as citizens of this country, we're really doing a disservice to our legislature. So let us pick up right where we left off, specifically when translating into the global context as well. Where exactly, when it comes to the new amendments that have been proposed and the new changes that are to be made into the existing cooperative legislature, where do you see the biggest issues, sir?
The biggest issue is they want to break the cooperative society into 9 provincial cooperative society, that is laws. Now, that, I mean, the purpose of, as I said earlier, the purpose of cooperative to collect more money, collect more wisdom, collect more labor into one, put all these, accumulate all these things into one particular place so that there will be so much of strength in it. So the government should understand, by dividing the cooperative into 9 different parts. What do they mean? They want to abide by this 13th Amendment thing. From my point of view, it's true that it's in the list, but conceptually, it is against the Constitution, I should say. Why do I say this? It is because the cooperative definition very clearly states that it is samma upakara, the correct way of helping each other. That is, helping the entirety and the entirety helping the singular, right? And to do that, there should be a guiding line, a policy. Now, all the laws in the country is guided by one particular law, a norm. That is, now in the Constitution there are 2 particular section where it discusses the policy making process of the Constitution. And finally it says, especially in I will show you this chapter where it says that particular policy making chapter doesn't allow you to make those policies, to put those policies into practice. Now we are discussing about policy. Now this particular law which defines, that is paragraph 6, which section 27, article 27(1), the principles are being discussed. But it finally states that these policies can be taken up in a court of law. So the only policy which can be taken up in a court of law is the policy described in paragraph 2, that is regarding article 9, that is regarding the Buddha Sasana. And all institutions in the country should follow that policy. Any institution in the government is not allowed, no institution can be allowed to take a different path and say that they can create a law against Article 9. Now, why do I say this? The reason is this. Even the cooperative should be governed by the said Buddha Sasana law. In the recent judgment regarding the Ayurveda Amendment Act, the Supreme Court decided in the special determination matter that no one can go against the Buddha Sasana law. And that is a concrete determination.
That makes Article 9 completely intrinsic to the policy-making process.
Policy-making process. So, whereas when you make a policy, it should abide by this particular law. My argument is, if that is so, dividing the cooperative into 9 segments merely because of this 13th Amendment thing, it divides Buddha Sasana. That is, the most important institution in this country where all Buddhists gather together is the cooperative. And the state should abide by that law, and it is the duty of the state to protect and foster the Buddha Sasana. So, all the people who belong, all the upasakas and the Sangha, which is part and parcel of the Buddha Sasana, I mean, the cooperative is there. The real cooperative of the country is the Buddha Sasana. That is, it has an objective as well as a decision-making process where all the people take part in that decision-making process, and that is Buddha Sasana. So, this principle is embedded in the cooperative society's law as well. So, a court or any government institution cannot forget the fact that when you divide the cooperative into 9 departments, instead of having one whole thing to control, administer the whole thing, by doing so, they are violating Article 9 of the Constitution.
Right.
So, that is illegal.
Of course. I think it's important for us to actually delve into this specific area as well. So I'd like to ask you yet another question. When it comes to the rationalization or when it comes to justification of bringing this amendment forward for cooperative law, how exactly has the government approached actually justifying this amendment? And do you believe there's any solid backing to such a justification when it comes to the division of cooperative law?
No. I know the reason behind this is the government doesn't have funds to look after the cooperative society. I mean, it is the sole responsibility. I mean, what the government says is that it's not a profit-making institution. So, the cooperatives are not meant to make profit. For the British, it was the cooperative store, samupakara khade. What the average man understands about cooperative is the cooperative khade. But cooperative law is not cooperative khade. If you don't come across this principle proper, if you cannot define it proper, you will get into trouble. Because cooperative khade or the cooperative store or the satosa khade, as the majority of people know it, is not the basic thing. It is one out of the lot. Cooperative is a huge concept where you can use to come over a situation of, I mean, a scenario of this caliber, the situation which we have come across today. So, the only way of taking the country forward is through cooperative. And if it is the only way of getting rid of this menace is the cooperative, I can't imagine why the government wants to break it into
Multiple fragments.
multiple fragments. Instead, they should put all those people together. There are 8.7 million members in the cooperative, under
That's
the
a
cooperative
considerable
law.
number.
I think 14,000 cooperative societies. What the government should do is to bring all these people into one platform.
I think that leads into a very good question that I could ask you, sir. How do you believe we should approach the streamlining of cooperative law? What can we do to build upon the foundation that we already have to better strengthen cooperative law, in your opinion?
I think we should digitalize it. The only way of, now the problems regarding cooperative has been, the creator is the government. Throughout history, what the government has done was, going against the cooperative principles, instead of the members deciding upon what the cooperative should be, the government has impinged on the cooperative system and introduced authoritative regimes into the cooperative system, giving them discretion beyond their limit. Now, what has happened is, all the members have become slaves of the bureaucracy. Right? The original feeling that they are members of the cooperative has been lost. So, what we have to regain is, give them the opportunity to take decisions. Now, there is a barrier. That is, you can't put all these 8.7 million into one place and ask them to function as one in this scenario. So, the best thing is to digitalize the whole thing and have a cyber cooperative, where all the members could come out with their voice out and say, this is what we want. So, and now we have the movement for the, we have put up a blog on this matter, that is Save Coop Law, and anyone can check for this blog. In the blog we describe one way of solving this problem is to have a common cyber platform where all cooperative members can have their voice recorded in that, and they can go for a poll even, and we are going to organize that poll and say that all should unite towards saving the cooperative law. If they make this amendment, what will happen is, our strength is gone. The cooperative lose its strength.
So we should be focusing on amalgamation rather than segmenting it, into further fractions.
Exactly.
Right. So there is a serious issue with the amendment that's being brought up. Do you believe that if this amendment goes through, the future of cooperative law looks dire? Do you believe there's still room for evolution, sir?
Yes. We have all these principles laid in the Tripitaka. We have been practicing the cooperative system in the Sangha society. It's not meant for profit, whereas the Westerners thought the cooperative is meant for profit making. No. Now, I will tell you, Anuradhi, now in Bhutan, there was an issue, and the IMF wanted the Bhutan government to raise their gross national productivity, GNP. Whereas the Bhutan is a Buddhist country, Buddhist jurisprudence is discussed on many aspects, and the Bhutan government told the IMF that we are not concerned about gross national productivity, we are concerned about gross national happiness. Our people are content with what they have, with their strengths, and productivity is not the issue. And they gave a different interpretation to gross national productivity. Whereas in our system, the law is there, it's clearly embedded in Article 9, and it's high time, Anuradhi, for us to tell the world that we have a different cooperative, that is Samupakara, Samma Upakara.
So we've always had it. It's just that now we need to properly actually look for it, research it, and solidify what it means in Sri Lankan legislature.
Yes.
We are unfortunately running out of time, sir. I'd like to ask you specifically, when you mentioned the global aspects of this cooperative law as well, are we on a good standing when compared to other nations that employ cooperative law, or do you believe that we're falling behind?
Conceptually, philosophically, we are on a higher elevation. But due to this wrong interpretation of the cooperative, our practices have gone down. So we have to teach the members, tell them what cooperative is, and rally them round under one umbrella and go for a cyber cooperative where they will, because the governments come and go, but the cooperative should last forever.
Of course, the cooperative is almost a reflection of general society as a whole. It's our representative when it comes to legislative matters also. I'd like to ask you, sir, specifically when considering, well, we just spoke about the global context as well. I understand that cooperative law should not immediately translate to economic progress or economic gains, financial gains in the country. But do you believe that if we employ our cooperative law in an effective manner, that it could actually translate in a sense to our current economic state?
Definitely. What the government is trying to do is to sell the cooperative to Indian and Chinese multinational company. Ultimately, the spirit of the cooperative will be lost. So I think most of the cooperative societies have filed cases, made complaints against these bureaucrats who try to bring about injustice in this field, and they have their conflict of interest. I mean, I don't know why they are so much interested in selling things to others, because past governments have been selling things to other countries, and we are in a difficult situation. So if the bureaucracy is also prepared to do this, I mean, people will definitely go to courts and take proper action against them and save the court.
Right. That actually, I think this might be my final question, unfortunately, because time has come against us. What can we as citizens of this country actually do? What actions can we take on our daily basis in our individual lives in order to protect the legislature that has been made to protect us as a people?
What do you mean by protecting this legislature? Well, the meaning of legislature is important. Legislature is the people. So for us to look after ourselves, we should decide. Legislature is not the parliament. All the entrenched sections should be finally decided by the people of the country. And Article 85(2), as always I say, has the line of thinking which gives the people the power to decide what laws should be. The only way of deciding people for the people is to have a cyber parliament where they can decide for themselves without the interference of a middleman. The problem with the cooperative is they have planted middlemen. All the cooperative societies are politicized, and there are no political cooperative societies, but they have political programs in all the cooperative societies. To get rid of this and to have a common voice, singular voice, is to have a system where people can vote and decide for themselves in a cyber environment.
We need to individually take the effort to collaborate with our society in order to protect cooperative law so that it can properly function as well in the future, for the future generations to come. Unfortunately, that's all the time we have on this program. Thank you very much, sir, for taking the time to explain this very complex topic, specifically because it's not being spoken about as much in local media, while it's extremely essential because it's one of the legislatures that genuinely exist to protect the society as a whole. Thank you very much, sir.
Thank you very much for giving me this wonderful opportunity.
All right, well, cooperative laws are an essential part of a functioning and content society. Therefore, it's essential that we protect the foundations this law is built upon as citizens of this country. We leave you tonight with the words of Boutros Boutros-Ghali, the former Secretary General of the United Nations. Cooperative enterprises provide the organizational means whereby a significant proportion of humanity is able to take into its own hands the task of creating productive employment, overcoming poverty and achieving social integration. That's all we have for you on Law, Land and Liberty. If you had missed any of today's programs, you can always rewatch by catching us on our YouTube channel, youtube.com/OtherThanEnglish. Thank you for watching. Have a great night.